You're listening to the Smart Girl's Guide to BC Family Law. Today's episode
is a self-rep spotlight on the perils of provincial court.
Our spotlight features self-represented litigants in family law matters, so don't go away. Hi, this is the Smart Girl's Guide to BC Family Law, and we're here to help you understand and navigate the confusing aspects of divorce and litigation.
Going through a divorce can be emotionally draining, confusing, and incredibly expensive.
Trust us, we know.
But it doesn't have to be. Listen, we're not lawyers, but we do have personal experience as successful, self-represented litigants. And we want you to learn from our costly mistakes and give you the inside secrets we wish we had.
Look, our goal is to teach you the rules of this game, how the BC family law system works, and the steps you can take to reach a resolution as quickly as possible while spending as little money as possible.
Whether you decide to self-represent or hire a lawyer, this podcast is for you. Disclaimer, we're not lawyers and nothing herein is legal advice, but educational content and personal insight only.
All right, well, today we have a special guest with us, Leanne. She is a self-represented litigant who represented herself in 15 chambers applications dealing with everything from Section 7 expenses, disclosure, and child support. And Leanne's matter was initiated in the BC Provincial Court, so we'll be talking to her a little bit about that.
Welcome, Leanne. How are you?
Good. Happy to be
here. We're so happy for you to join us. And thank you so much for sharing your story. Great to have you on the show. So let's start off with the beginning. We'd love for you to share with our audience a little bit about your journey to becoming self-represented.
Sure. Yes. So when I first began my journey, there was a few things that I considered. And first was the cost of a lawyer. And that really made it prohibitive. Like I couldn't afford those costs. The second thing I considered was my exposure. So I was asking for disclosure. I had fully disclosed because I was an employee, so that was easy for me to do. And the Section 7 expenses I was seeking, I had already paid for out of pocket. And the third thing that was important to me is it seemed that it was really unfair that my ex was simply not willing to pay support for his own children. So my first application was in August 2022, and my last appearance was November 2022. My ex was failing to disclose according to our separation agreement and pay Section 7 expenses. I was asking for braces, autism testing, and driving lessons. I've, like you said, I've appeared 15 times in front of the judge, both in Supreme and Provincial Court. And on all except one occasion, I was awarded what I set out to seek.
Wow.
That's amazing, Leanne. Like, that's such an incredible story. Did you say between August 22 and September or November 2022? So over the course of really 4 months, you were in court 15 times?
Sorry, no, August 2020. So over 2 years.
Over 2 years, yeah, and 15 appearances. Yeah. Wow. And I mean, I want to hear more about, the intricacies of what you face and some of the challenges that you encountered. But I wanted to talk about having a Mackenzie friend, because you had one at your trial. And a Mackenzie friend, for our listeners, is essentially a service person, someone that can sit with you at the bench, cannot be a lawyer or a paralegal, but a friend, a family member, someone that you trust. You can confer with them. They can help you organize your materials. And Leanne, I'm sure you face this. You have to get, the court has to agree before you can introduce a Mackenzie friend. But typically courts are agreeable to this. And I think this is an example of one of the ways that the system is trying to support self-represented litigants by having them, be able to bring a Mackenzie friend to court. So maybe can you tell us in what ways your Mackenzie friend supported you?
Yes. So I was really overwhelmed with the idea of going to court on my own. So the thought of having someone be able to sit next to me while I presented to the judge was something that made me push forward. My Mackenzie friend was my fiance, Carlos, and he was able to take notes for me. He was able to make quiet suggestions. And most importantly, he was able to organize my documents. So presenting to the judge, he would hand me certain documents that were relevant to what I was saying. And that was, it's really difficult to be up there. And I can't imagine doing both, speaking to the judge and looking for documents.
Well, I did that, and it was at times a little chaotic because I would, would have things in the wrong place. And so in retrospect, I wished I'd had a Mackenzie friend. It would have made things much less stressful and much more organized.
Yeah. I don't think I could have done it without him. So So I also found he was an amazing emotional support, able to also see things clearly, pay attention to what was happening in the courtroom, the details. So, while I was reading what I needed to, the judge would be looking at the opposing counsel, and there was just some details that I would have missed, not someone in there seeing what was happening in the courtroom. So my picture was much more clear having Mackenzie friend.
Yeah, like an extra set of eyes and ears is so valuable, right?
Mm-hmm. There's a bunch of subtle communication that happens in a court.
Yep.
Talk to that a little bit more about listeners. Like what was your experience like being in court with those subtle cues? And then also, how did you go about, for someone who wants to get someone to support them as a Mackenzie friend, how do you go about the judge or masters allowing you to have that? What's the process?
Oh, sure. Yeah. So it's quite easy to search up, and they want you, when you first go into court, you make a request to have a Mackenzie friend. You are very clear what the things that your Mackenzie friend will do. So they will take notes, organize documents, and be emotional support. And then you're also very clear about what they cannot do. So they cannot give legal advice. They cannot speak directly to the court unless they're spoken to. So the other thing that's important too is that the other side is not objectionable to having that person there. So it's smart. And I think they do suggest that you send a letter letting the other side know that you will be requesting a Mackenzie friend. But in all of the cases that I was in front of the judge, I was allowed to have the Mackenzie friend, and my ex didn't object. But I don't think, yeah. So it's you want to make sure that you're picking someone who doesn't have a conflict. So yeah, and that's what the judge is looking for: someone who's going to be respectful and
That's right. Yeah, and it can't be like a paralegal. It can't be a lawyer. It has
Right.
to be someone who doesn't have a legal background.
Yeah. Leanne, 15 chambers applications. You were in the provincial court primarily, and then you had to do, I guess, some appeals to the BC Supreme Court. Can you tell us about how your experience was with the judges and masters that you appeared before? And was your matter seized? So did you have the same judge every time?
Yes. So in provincial court, my case was seized to the same judge. So I found that first experience for the judge was very impatient. So the first time I appeared, I worked really hard to be prepared, but my ex was not prepared at all. Unfortunately, initially, the judge lumped us together as self-reps all the same, and she would dismiss my claims like they were childish disputes, and she would constantly interrupt me. And as a self-rep, this really threw me off. So having my Mackenzie friend there was really helpful to keep me on track. I think if the same judge had known her constant interrupting had prevented me from having the opportunity to share my story properly, she wouldn't have interrupted as much, because there were a few times where the same judge was also helpful. When I filed one of my documents for trial, I didn't include the cover page of one of the exhibits. And the judge could have said it was inadmissible, but instead she guided and explained that if the other party, my ex, was to confirm the document was from our financial disclosure in 2015, then she would allow it to be admissible. So when my ex was in the stand as a witness, I asked if the document was his financial disclosure from 2015.
Right. So she let you authenticate it on the stand. Yeah. Good.
And yeah, so she was seized to our case, and eventually she began to see that my ex was uncooperative, and she began awarding fines for the behavior and educating him in one particular appearance that she had the authority to send him to jail. So yeah, so
almost as a warning to say, listen, that I could do this, so just watch yourself and kind of get yourself in check. Good.
Mm-hmm. And then Supreme Court experience was different. It was much more structured. A few of the judges would say that they could see I was nervous, but to take my time, and that they were there to listen to what I had to say. And I feel this style made it way easier for me to present my facts, and made an outcome that was fair.
Yeah, and I do know that I was just going to say that I do know that the judges undergo quite a bit of training in terms of how to deal with self-represented litigants. On the first day of my trial, the judge actually gave me the package, the guide to self-represented litigants, as a resource that she wanted me to have before the trial got underway.
Wow, that was insane.
Mm-hmm. Yep.
Something that stuck out, Leanne, which I experienced as well going to chambers, was opposing counsel eating up time when it was my chance to speak and to respond to their application. And I remember having to fight and actually like tell them, the judge, we had a judge in that application. I said, your honor, I'm not able to speak because she keeps cutting into my time to speak. And you do have to be really assertive, because I find opposing counsel can sometimes be quite aggressive and just eat up your time knowing that you are a self-represented litigant. So on that note, I'm curious, tell listeners about what your experience was with opposing counsel that your ex-spouse had. What was that like?
Yeah. So I found him to be very adversarial. So the judge that was seized to our case eventually became frustrated with multiple ungrounded applications from my ex. And she told him his file was flagged and he was not to make any more applications without legal advice.
Wow.
So when the lawyer first appeared on the scene, I was relieved because I thought finally someone would be there that could explain to my ex what the judge was saying and her reasons for judgment after our trial in April. And we would be able to avoid further court appearances, as that's been my experience when I dealt with my lawyer initially when we had our assets divided. Unfortunately, what happened was the lawyer that my ex had hired tried to take advantage of the fact that I was self-representing. So in March, we appeared at a remand hearing where the lawyer stated he'd just been hired that very morning to represent my ex. The next day, the lawyer sent me a threatening letter saying if I didn't agree to his terms, he would apply to a higher court. He had not even seen the order he was appealing because it had not even been written yet. So without waiting for my response to his threatening letter, he filed an application to Supreme Court. On the application, he said that I had outright refused to cooperate and that my refusal had caused him to file the application.
Wow.
I tried to communicate with him on a number of occasions. He did not respond to emails and he would not answer phone calls. In August, the Provincial Court made a change in quantum to be paid for child support. The same lawyer was told to write up an order so that the child support that was owed to be by my ex for over a year and a half could be collected. But instead, the lawyer did not write up the order. He sat on it and ignored my attempts at communication. Eventually, I was forced to appear again in court to have the order enforced because without the order, I could not collect the child support that was owed. In the end, hiring a lawyer with an adversarial style resulted in several unnecessary appearances where my ex, his client, did not even get the changes he was seeking and was even fined on some of those appearances. The judge specifically stated that the lawyer had outright ignored her orders and caused to be awarded. Since then, I've taken the transcripts from the court appearance and presented them to the Law Society, and it's now under investigation, and things seem to be moving in the right direction.
See, and that's such an important thing for our listeners to know is that, litigation is an adversarial process, but unfortunately there are lawyers that are really unethical and don't play by the rules and will try these very sneaky, underhanded attempts to throw you off and to lead the whole matter astray. And so I'm so glad that you persevered and that it was obvious to you and to the court, and that you've now taken it to the Law Society so that there can be some consequences for that.
I was just going to say it did take a while for the system, like they gave lots and lots of chances. That was difficult to keep pushing through.
Yeah, and judges are all lawyers to begin with, right? Yes. So I think that there's a little bit of like we want to sort of protect our own, and they kind of feel like you're a lawyer, you've got this duty of candor, you've got this duty of policing your client's conscience, and that they will do that. But in many cases, I know in a lot of cases, that
I just want to take
happen.
a second to mention that to our listeners, the Law Society and filing a complaint if opposing counsel is operating in a way that's unethical. I do encourage you to take a look and see what the grounds are for making a complaint. I had a similar situation in my case when one of the lawyers of my ex was disclosing my confidential information to third parties, and I filed a complaint, and that lawyer then actually resigned from the case. So it is important to stand up for yourself, because I do find that, as a self-represented litigant, you have to be tough, because the lawyers will come after you and try to bully you and use that. It is bullying.
It is bullying. That's exactly
and
what
intimidate
it is.
you, right? By writing threatening letters, making short terms.
Yeah. I was continuously told it's trait law, blah, 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 blah. And then I would go and look it up and I'd be like, no, it's not. No, it's not.
And
Yeah.
legal bling is an actual term they use, because I remember hearing that a few times when I would explain what was happening.
Leanne, tell us about your legal research. You know, we've done podcasts and talked on some of our other programs about the importance of legal research. How did you navigate the complex process of having to put together your arguments and the case law that you were relying upon?
So I used a number of sources. I used Duty Council, Legal Aid of BC, the Law Library, Unbundled Services. Sometimes the registrar can be helpful. But mostly I got a lot of advice from talking to people through the process. It was that support from people out there. If you talk to people, there's so many things you learn from other people having already gone through it. So, but it was a combination of things. And I had this long list that I wanted to share, but sometimes, unfortunately, you find out about these services after, when you could have used them at the time. But yeah, it's tricky. It's tricky because sometimes they don't suit your need too.
Yeah. So what would you say are the top 3 things that you think self-represented litigants need to know as they're embarking on this journey? What would you say are the top 3 things that you would want people to know?
So I feel that both transcripts and court summary sheets are a sub-rep's best friend. So they help you to review and understand what happened when you were in front of a judge, and they help you to hear more clearly what was said and look into some of the legal terms used during your appearance so that you have a better understanding if you're in court again. And if you need to prove something that was said, and that you're not a self-rep who misunderstood, you have those transcripts to back up what you're saying. Using a Mackenzie friend was also really helpful, to have someone there for your emotional support, as well as having someone who knows your case and can talk to you about it. There's so many peaks and valleys in the journey, and having someone to talk to when things happen helps you better manage your mental health. And staying strong and in the fight. So you don't need to win everything you set out to seek, but being heard in the end is the big reward.
That's such a good point, is like, make your North Star goal and focus on that. Because I think when you're dealing with an adversarial opposing counsel and ex, they can try to deter you from everything and really try to distract things. And you have to focus on your offensive strategy. Like, what is your goal here? What are you focusing on? And don't let all the distractions kind of cloud that, which is so easy to happen when you're dealing with someone that is a bully.
Yeah. And the tenacity, right? The kind of not losing sight of what you want. Like, you know, if you know that you're entitled to disclosure and you're just not getting it, not giving up on that. I mean, I had to go back to court. My first application for disclosure was dismissed. I went back again and got an order. And then subsequently came to learn just how much had not been disclosed. But if I had given up after that first application, I or the court never would have known what really was taking place.
Yes, definitely.
Well, Leanne, I think it's just so encouraging to hear someone else's story, right? How they've done it, and you stayed strong and you persevered. And sometimes that's, like you said, we just need to hear other people's stories as a message of hope that you can do it. Don't get scared, keep pushing through, and keep strong as you're going through your trial and your family law matters. So thank you so much for joining us and for sharing your story. And we know this will inspire a lot of our listeners to keep pushing forward in their matters as well.
Well, yes. Thank you both for doing what you're doing. I'm really excited because I think it's all going to be helpful to other people who want to self-represent. So thank you.
Head on over to smartgirlsguide.ca for free and paid resources to help you with your divorce. That's smartgirlsguide.ca.
Disclaimer. We are not lawyers and nothing herein is legal advice but educational content and personal insight only.
Catch you on the next episode of Smart Girls Guide to BC Family Law. Bye!
Bye.